All right, welcome to Life in the Law. I'm your host, Ken Lawson, and with me today is he's been here before earlier, but there's so many things going on in our judicial system that I had to ask Myles Breiner, Attorney Myles Breiner, to come back and join us for this segment. Um, and I'm glad that you're here, Myles.
It's a pleasure.
All right.
It's a pleasure.
And we're going to talk today a little bit about a lot of cases. You know, you handle a lot of high-profile cases. You take cases and you win cases that most lawyers can't win, right? And
I like to think so.
well, you do. I mean, the record speaks for itself. And we were talking off the air, you know, and not to blow you on, but I will because you've earned it, you know. And there's, you know, there are good lawyers and there's good lawyers with the heart of a warrior, and you have that heart of a warrior, man. I mean, from one warrior, former warrior, to another, I'm telling you, brother, it's hard to find.
It's a fairly simple standard. The same standard you have when you were practicing law. You want someone to defend you the way you would defend yourself.
That's it. That's it, man.
Right. And it's very simple. It means communication, whether it's you make a phone call to the office, you respond to the phone call, email, contact, to be responsive to your clients. It's the same thing I would want for someone representing me.
Right.
So effectively, I mean, to be an effective attorney, you know when you're being effective when you're the sword and the shield. Yeah. When you're the sword for your client as well as a shield.
And I think that's what most clients look for, man. They look for somebody who's going to fight for them, you know, who's going to stand up and not be part of the system. I mean, because there's a lot of perception out there that, you know, this is a good old boys network, and maybe we have to get somebody from California to come in here to try my case because everybody knows each other. But you set a different standard.
It's the kind of practice that I have. I mean, I'm presently the president of the Hawaii Association of Criminal Defense Lawyers. This is my second go-around. I enjoyed it 5 years ago, and I did it for about 3 or 4 years, and recently, just effective at the beginning of this year, just the other day, January 1st, I'm the new president.
Awesome.
And I wanted to take over that job again because I wanted to get out and be an advocate for other defense attorneys, both public defenders as well as private attorneys and court-appointed attorneys. There are too many people in the community that think that being a lawyer is not a fulfilling job, that it's all about the bottom line, how much money you're going to make. And the bottom line for me has always been, if you love something, really enjoy doing it, you make money at it. There's no question. Because if you don't enjoy what you're doing, you're not going to be successful. I'm successful to that extent because I love what I do. It's a separate high, just simply helping someone when they're desperate, being their savior, or in some cases their sword, their shield, or just being there for them makes all the difference in the world. And I'm a bad loser.
That's important. To be a good winner, man, you got to be a bad. But you know, that's important. And I tell my law students this all the time. Whatever type of law you go in, make sure that you love what you do. There's nothing like going to school for all these years and then working in a job where you just can't stand to go to work.
Well, you were a trial lawyer before you were a professor at the law school. I discovered when I was in my second year of law school, I went to school up in San Francisco, I had the opportunity to work on a case, to try a case under the district attorney's office. And it was a jury trial. I had my first jury trial when I was in my second year of law school. I was a prosecutor, and it was like someone plugged me into a wall socket. It was wonderful. Any notion of not being a trial lawyer that evaporated at that point. It's very, very satisfying. It's the ultimate chess game. It's a set table, you know exactly what the evidence is, and it's interesting. It's interesting that the tactics and strategy that you have to employ to be successful. You're dealing with the police, with the prosecutors, with witnesses, your own clients, all the variables.
Absolutely, and I used to tell people, you know, I love sports, and I was too small to go and play professional football, right? But trial work, criminal defense work, just trial work, period, was the closest I could get to contact sports, you know, because it was a battle.
Without getting a brain damage on it.
Right. It was a battle, you know.
No, it's true.
But I think, you know, you point to an important aspect of it, that is caring about your client to the point where you're willing to go to the wall for them. Obviously, you know, not to violate any ethical rules or anything like that, but to you know, to go down swinging.
I had that experience. About almost 25 years ago, I went to jail in the middle of a murder trial. I I went to jail because I couldn't keep my mouth shut and kept pushing the envelope with the judge. But the fact of the matter is that I noticed that after I had done my weekend in jail, the general word around town was that Mr. Breiner would go to jail for you. I went to jail because I was foolish. You know, I had a lot of growing up to do. But the bottom line was that I pushed the envelope because I believed my client was innocent. And I felt that the judge, who was not retained after her 10-year cycle came up, was acting inappropriate and was just another prosecutor in a black robe.
Yeah.
But
And that's hard to deal with, man, especially when you care about what you're doing. So, you know, I don't.
would I have done it different? Probably not. Maybe a little less vinegar, maybe more honey this time.
It is, you know, that's the hardest, that was the hardest thing for me to learn how to do, is control my temper in the middle of a courtroom, especially in a battle like that, because lives change. I mean,
Right.
you know, I mean, when those courtroom, when the courts are closed, and if you're there late, you know what I mean, and you just hear the silence of those hallways, you realize how many voices that have screamed out in pain and cried out in just sheer agony over hearing their loved one being sentenced, taken away.
Well, you know, as an attorney, that all you ask for is an even playing field. You're not asking for a judge that's pro-defense or favors your client. All you're asking for when you walk into a courtroom and you got your jury is an equal opportunity to go in front of the jury to present your case. That may sound like very simple, but the fact is that it's very difficult to get judges to give up their agenda. We have some judges that are very fair, that I know when I pull them as a possible judge for a trial, that I know that I can present my evidence. They're going to rule against me, that's fine, but at least I get to present my argument. It's the judges that don't, that they have an agenda. Some of them are ex-prosecutors, some of them are simply inexperienced, and rather than concede something to the defense, they're more concerned about getting reappointed, or at least not alienating the prosecutor's office or prosecution in general.
Absolutely, and it's such a scary system because, you know, when you pick jurors, I used to ask them, you know, how do you presume my client innocent? I mean, how many of you walked in here and looked over at the table and said, I wonder what this man did, as opposed to I wonder what they accused him of, right? And the presumption of innocence. How many of us wake up in the morning, read to somebody, hit somebody, and got charged with DUI and say, you know, I wonder if he's actually innocent? Or do we just say, you know, look what this guy did last night,
you
know?
Our system of justice, you know, in a jury trial, it's supposedly being tried by your peers. It's very rare that the person sitting next to you with your client has any kind of relationship as a peer to the people that are in the jury box. Most of the time your clients aren't necessarily wage earners. Sometimes they're not even registered voters or paid their taxes. And whereas everyone in the jury tends to be either fairly conservative, they pay their taxes, they have a driver's license. An example that comes to mind is I had a young guy from California, from Florida, with dreadlocks. And the entire jury pool, there wasn't a single African American. And here I have a guy who's originally from Jamaica, but grew up in South Florida, has the dreadlocks, has the gold teeth and the whole bit. Okay, that's how he sees himself. There's nothing wrong with that. But I was concerned that the jury was alienated because of his appearance. And the only way to address that was to identify the racism implicit with the jury. So I asked each one of the jurors, would you rather be prosecuted, if your situation, you're faced with a crime, would you want to be prosecuted in Hawaii or in New York? Every single juror said, I get your point, Mr. Breiner. I'd rather be here in Hawaii with people that are like me. So I said, well, how do you think my client feels? He's worried that because you don't have any experience with African Americans or with guys who appear to be Rasta or whatever, that he's not going to get a fair trial. It worked. The jury acquitted.
Right.
The jury was out for 35 minutes and they acquitted him.
And that's, you know, I used to tell my young associates, and I tell that voir dire is the most important part of a trial. You do a good voir dire and a good opening statement, and you got the evidence to back it up, you walk your client after open, right? The rest of it just putting on.
One hopes so.
Well,
but it's tough.
But a good voir dire and a good opening statement, just being straight up with the jury. You know, how would you feel if you were in Harlem being tried by an all-black jury, where the judge is black, where the court reporter is black, where the deputy's black? You know, what would be the first thing on your mind? And then they would tell me, I don't want to be convicted because I'm white. Right?
Well, there was Tom Wolfe's book, Bonfire of the Vanities.
Yeah. Yeah, absolutely. You know, now going back to you being president of
Hawaii Associate Criminal Defense Lawyers.
There's a lot of things that's happened this year, and it seems like the criminal defense lawyers need a voice. You know,
I think so.
when you work in a small community like this and you have to make a living as a criminal defense attorney, every day you got to see the same prosecutors. You're going to have to make some deals, right? And so there's a tendency to get along as opposed to create any
Friction?
Any friction, right? And so,
If you want to get along, you go along in that notion.
Right.
And the fact of the matter is that I wasn't put here on earth, you know, to curry favor with prosecutors.
Well, that's why you're
or
sitting in that
judges.
chair right here, brother. If you was here, you know, I couldn't. That's why you're here,
You know,
because you don't have that reputation of going along just to get along. And so,
I have to admit, I notice this other attorneys when I'm in court, they ask to go ahead of me for fear that I'm going to really piss off the judge. Be that as it may, you know, that's the way life is.
and I used to have clients that would ask me that question too. They say, you know, Mr. Lawson, you know, we came here and we know that you're good, but you know, some people said you really piss off the judges down there, right? You know, and my response would be, you know, that that's part of representation. I have to at least stand up, and my intent is not to piss off the judge, but my intent is to present the truth and defend you.
True. Absolutely.
But over the last year, I've commented in the media on some of the cases you've been involved in with respect to what I consider some very serious problems in the prosecutor's office.
There are some serious problems. Recently, we had a 414-count indictment thrown out by the circuit court judge, Randy Lee. We had hoped it would be with prejudice, which means can't be brought back. It was done without prejudice. However, the court concluded that the prosecutor's office were completely inept in their decision-making on who to appoint to take the case to grand jury and to prosecute. Although one of the deputies had been first deputy in Kauai, had 4 or 5 years experience, and the other deputy was the head of the career criminal unit at the prosecutor's office with 25 years experience, the court still concluded that they were not properly supervised, that the fact that Mr. Kaneshiro, the chief prosecutor, had appointed the wrong people to handle the case. As a result, the entire indictment, all 414 counts, were flawed. Dismissed because they were inherently flawed. The problem is that the people lost their livelihood. There were 9 defendants. All the defendants had their money seized, their property seized. They had a place. Some of them went to jail.
They were all over the news.
Had to bail out. It's very humiliating because none of them have criminal records.
They were all over the news. I mean, this was a case. It would be different if this case had been done to where it wasn't being prosecuted in such a public forum. But and I may be wrong, you correct me, but it seemed to me that once this indictment came out, somebody in that prosecutor's office notified the media, you know, and they had all these games coming out, the places of business.
Well, let's put it in context. There was 2 years prior to the indictment in this case, this 414-count case in state of Hawaii versus Tracy Yoshimura et al., all 9 defendants. The prosecutor's office, in conjunction with the police department, Honolulu Police Department, had gone around town and seized machines and shut down game rooms for about 2 years. It's been going on. And there was a civil lawsuit filed by a local attorney, Keith Kiuchi, a very competent, very good civil attorney. And Keith was pursuing this matter and ended up being transferred to federal court. On a Wednesday afternoon, several months ago, last November, I believe, Judge Leslie Kobayashi, federal district court judge, ruled on an issue that resulted in summary judgment being granted to the defendants on some of the issues. And then, of course, you know, it's going to happen. You appeal it to the Ninth Circuit. Within 24 hours, the prosecutor's office brought that case before a grand jury and a 414-count indictment. Within 24 hours.
We have to go to a break. When we come back, I want you to pick up on that. Because my next question is going to be, why do you think that is? But we'll wait till we get back.
Okay, all right.
We'll be right back. This is Ken Lawson. You're watching Life in the Law. Our guest today is Myles Breiner. We'll be right back after this break.
Aloha, I'm Keli'i Akina, president of the Grassroot Institute and host on Ehana Kako, a weekly program on the Think Tech Hawaii broadcast network. Ehana Kako means let's work together. Think of the sad alternative, let's not work together. Here in Hawaii, with all of our diversity and the richness of the people, it's important for us to come together around issues on the basis of what's right and what's good and what's going to serve the common good. And that's what we try to do at Ehana Kako. Every week, we interview movers and shakers, people in government, business, and other sectors of society to talk about how to create together a better government, economy, a better world here in Hawaii that can bless the rest of the world. I thank you for your attention to Think Tech Hawaii, and we look forward to seeing you every Monday, 2 to 3 p.m. on the Think Tech Hawaii Broadcast Network. We're Ehana Kako, and we wish you well. Aloha.
All right, we're back with our guest, Myles Breiner. You're watching Life in the Law, and I'm your host, Ken Lawson. And Myles, before we went back, you were talking about the case in federal court, the civil case against the I guess?
There was a civil case filed on behalf of Tracy Yoshimura and other owners of devices, and that were swept up in this investigation 2 years ago. That case, originally there was a lawsuit filed in state court on behalf of Mr. Yoshimura and the other owners of the game rooms and the machines by Mr. Keith Kiuchi. That case was transferred to federal court, and there was a summary judgment motion filed by the defendants. And the defendants were Keith Kaneshiro, the chief prosecutor, and Chief K. Aloha, the chief of police, the Honolulu Police Department. The court ruled that, had determined, at least for purposes of an appeal, that the machines that were seized could be in fact deemed gambling equipment and be in violation of state statute. Okay. That being said, the case would then be appealed to the Ninth Circuit, right, where it is right now, to be determined whether or not there was sufficient evidence that these are actual gaming machines, as in violation of state and federal law, state and county law. Within 24 hours, the defendants in the civil case, Keith Kaneshiro and Chief of Police, Louis K. Aloha, brought this case before a grand jury.
Hey, man, I'm telling you, you know,
go ahead. 414 counts. And the person assigned to prepare these counts, Jake Delaplane, who had previously been first deputy in Kauai, had just recently been terminated, or he had voluntarily left his position in Kauai, and was only in the office of the prosecutors for 2 weeks. So in 2 weeks, he was rushing to put together a 414 count indictment. Now, subsequently, Mr. Delaplane testified under oath on our motion to dismiss the case with prejudice that he never even read his own discovery in the case.
Right. I mean, I read that before I commented to the news.
22,000 pages of discovery.
I couldn't believe that.
And he hadn't read a single page, according to his testimony. He relied upon summaries from people that he can't identify. He forgot their names, and took those cases, that information, and went before a grand jury and put on witnesses, in particular a witness who was not qualified in federal court as an expert, yet he put him on in a state court and let him testify after first stating that he'd been qualified as an expert in federal court. As to what, we don't know, but the grand jury's impression was that this guy was testifying as an expert on the issue of the unregulated gaming machines. When I read the transcript, my impression was he presented him as an expert on those machines, those gambling machines. Correct. And so it wasn't until I got later on into the decision that I saw where the judge said, or basically that this guy should have known that he was an expert. And he had to have known. I mean, because he asked him a series of questions, and the questions all were prefaced with, "You were qualified as an expert in federal court." Right. And he would answer affirmatively, and then he asked another series of questions, essentially justifying rationalizing his opinion that the machines, these non-regulated games at these gaming rooms, qualified as gaming machines, as gambling machines. And the fact of the matter is that this gentleman, this guy Myers, was a casino owner with a casino license from Vegas. He had a vested interest in stopping legalized gambling in Hawaii. Can you imagine how much money Vegas would lose if there was legalized gambling here? So he had a vested interest. None of that was presented to the grand jury, nor was it presented to the grand jury that specifically he was found not to be an expert on the machines that were an issue in the lawsuit in federal court.
And his boss was in there also, right? When this testimony was going on, so she could have corrected it.
Easily. The supervising deputy.
For those that are watching and really don't understand the difference between a grand jury and a petit jury, et cetera, and we've seen in Ferguson, we saw in New York, where the prosecutor used the grand jury, and the grand jury comes back with a no bill people were upset at some of the evidence that was presented.
And they have
in
every reason
Ferguson.
to be, because the bottom line is that the grand jury is a
Here we go.
creature of the prosecutor's office. We hear that phrase all the time. It's bandied about in the media, on television. But the bottom line is, defense counsel is not invited into the grand jury. It's solely the prosecutor, the witnesses the prosecutor wants to put on. They have total control over crafting the testimony. If they want to obtain an indictment, they get an indictment. So the notion, for example, the Ferguson case involving Brown, the fact they couldn't get an indictment does not surprise me, because I submit that the prosecutor didn't want an indictment.
Oh, yeah.
Had they presented the evidence in a different way,
They would have gotten one.
most likely.
So how easy, and the reason why I brought it up is, the system is not supposed to be abused. But when I read the transcript in this gambling case, man, I mean, it was just, I'm sitting there, I'm shocked.
Well, I'll put it this way. The transcript for the grand jury was roughly 200 pages long. Okay? That's an enormous transcript.
I didn't read all that, yeah.
Okay. According to Judge Lee, who threw the indictment out, after page 30, he was, quote, sick to his stomach, unquote, after reading the kind of evidence they put forward. Excessive hearsay, misrepresenting someone's status as an expert. I mean, there was one issue after another. And
They named somebody, one of the defendants is owning.
My client had, of the 414 counts, my client was charged with 157 counts.
Yeah.
157 counts. That's astounding. And on all those counts, they
I'm
had it
laughing
wrong.
because it is astounding. I'm sorry.
Well, I mean, he lost his business. He lost his income. He has a wife and children. So he's basically scraping by. His family's assisting him. And the reality is, this is probably not good business decision on my part. I took on the case, and frankly, have yet to be paid.
But that is, but like you said, I mean,
anyone watching what happened, anyone who saw what was occurring in the case, would recognize that it was truly an injustice, what was going on with all 9 defendants, not just Mr. Yoshimura, my client, but all of them were being targeted by the prosecutor's office and HPD. And the fact remains that other people in this community had the same machines while this case was occurring, and they still have their machines in their game rooms, and they're not being charged with any crimes. They've gotten cease and desist letters, and in most cases they've removed the machines or shut them down. For example, Fun Factory has some of the same machines, Dave & Buster's, yet the prosecutor's office is not taking on corporate America, and they're not about to go and charge the general manager of Dave & Buster's or Fun Factory for Hawaii, you know, as a criminal engaged in gambling.
Selective prosecution then too.
Very selective. And again, this was all payback for Mr. Kaneshiro for Mr. Yoshimura and the other defendants originally suing Mr. Kaneshiro in a claim of abuse of process, abuse of his position as a prosecutor.
Wow. Now you've been able to sue.
Well, we've,
which is enough. Most people don't know this, you know, because it's so many prosecutors are given immunity.
Correct. In their prosecution function, so long as, and the law has, unfortunately, over the years, our U.S. Congress and the U.S. Supreme Court have narrowed down the opportunities for seeking redress for prosecutorial misconduct. If a prosecutor makes an error, egregious or otherwise, in the course of prosecution, generally speaking, they have immunity from being sued civilly. There's a very narrow area. You have to show that it's egregious or it's malicious, which is very difficult to establish.
Or a pattern and practice of a
pattern
civil
of practice,
rights violation.
a civil rights violation. Correct. There is one other exception. If the complaint about conduct falls within an administrative category, in other words, not necessarily the prosecution of a case, but the appointment of prosecutors to take a case to grand jury is an administrative function. If it's determined that that appointment was done erroneously, or if they appointed the wrong people, then there's an opportunity to seek redress, which is what we've done.
And that's a novel approach.
It's rather unusual.
It is.
So, presently, Mr. Cucci and I filed a lawsuit approximately 2 weeks ago against the chief prosecutor, Mr. Kaneshiro, and the 2 deputies and the investigator in the underlying criminal case, suing them for damages based upon the failure to properly supervise, train, and exercise authority over these deputies when they took the case to the grand jury. I mean, the notion that a sitting judge who used to be head of the white-collar crime unit of the prosecutor's office would take a look at the grand jury transcript and conclude that there were so many violations that he felt entitled, necessitated, telling all the attorneys. We've had a number of status conference meetings with the judge, insisting on telling the attorneys, defense and prosecutors, there are terrible problems with this indictment. Please file the appropriate motions to resolve this. And that was from day one when the indictment came down and we met with the judge.
And in fact, they tried to dismiss it,
well, they tried to dismiss it, and they initially kind of after hours, sub rosa, filed an ex parte motion to dismiss without prejudice. And fortunately, under State versus Estrada, we're entitled to a hearing, whether they want to dismiss it with or without prejudice. We're entitled to have our day in court. Now,
that's a beautiful law, man.
Well, much to Judge Lee's credit, he signed, without being aware of this, he signed the order granting the dismissal without prejudice before he had a chance to see what was really going on. And we were allowed the opportunity to present evidence. We had
got a motion to reconsider.
A motion to reconsider. We had a week-long testimony by some of the prosecutors and people involved in the underlying case.
I'm surprised that prosecutor took the stand, man.
Put him under subpoena.
That
was good for the goose, is good for the gander, my friend. You know, they don't like it, but he was on the stand. And on the stand, he invoked the same comment over and over again when confronted by my cross-examination, the other attorneys. When the judge cross-examined him, asking questions from the bench, his response was, I can't recall.
Yeah.
I can't recall. That was his favorite reply to his decision-making that occurred in the case. But what was clear, he finally admitted, example, he never read his own discovery. He never read the 22,000 pages of documents to support the underlying indictment when he took the case to grand jury. That in of itself doesn't make any sense to me. And
that's dangerous. I mean, like you said, your client has lost his business. He's been paraded all over the news as some type of gangster, you know. Lost everything.
He's a former paramedic.
Family's devastated.
He's decorated. He's received commendations as his work as a paramedic for years and years. He's a legitimate businessman, always paid his taxes, doesn't have a single thing against his name, no misdemeanors, no crimes whatsoever, but he's been characterized and vilified by the prosecutor's office, you know, as a dangerous individual who wants to introduce illegal gambling in Hawaii.
That's a heck of a lawsuit, man, because when you look at it, to sit there and say that, I mean, you charge me with 100 and some odd counts in an indictment, and you haven't even reviewed the evidence? I mean, that's some dangerous stuff. Remember the case where
which is it's understandable why the folks in Ferguson and in Chicago and all the other places where you're seeing these police shootings and they're not getting indictments, why they're outraged.
Yeah.
And you flip it the other way. When O.J. Simpson was acquitted, there was this hue and cry that the system's been abused. But the fact of the matter is, the country got what it asked for. He had his day in court. He had good attorneys. The prosecution couldn't pull their case together. They had too many contradictions in the evidence. He prevailed. Now, people don't like that, but the fact of the matter is the system worked.
Right. And in here, you know, and so many, I don't know, what makes a man who's not getting paid, right? You know, you couldn't take the case. There's something inside you that says, you know what, I have to stand up for this guy. Well, and then to sue the prosecutor where you had to go in every day and try to get along. What makes a man do that?
Doing the right thing. The bottom line is, you know...
That's more than that, man. It's a lot of courage, too.
You know, but for the grace of God go I.
Yeah,
you know, you have to wonder, you know, if I don't do this, who else will?
Right.
There's an old Hebrew saying, if not I, then who? If not now, then when? Maimonides.
Yeah, and I commend you for that, brother. I mean, I really do, because, you know, our hearts speak the same language. And so, I've been on the front line, and so to sit back and watch you do it, you know what I mean? I know the courage it takes to say, you know what, I don't want it, because in some cases you don't want to do it, right? But you know that you can't help but do it because that's just who you are.
But I appreciate the praise. The bottom line is I'm having fun.
Oh yeah.
You know, it'd be nice to get paid, but the bottom line is once in a while you have to take on a case, you know, that maybe the money's not there initially, maybe it never will be there. But the bottom line is it's the right thing to do.
Right.
No one else is willing to step up to the plate.
All right, we're going to take a quick break, and we're going to talk about a few other cases because, again, it concerns me, some of the things that I've seen over the last year or two coming out the prosecutor's office. And what also bothers me is it's almost as if maybe the public's not so much aware of it, but in any other city, there would be a little bit more of an outrage, and I want to ask you why is that not here? I mean, but anyway, we'll be right back to talk about that issue after this break.
Hi, I'm your host on Think Tech Asia, Bill Sharp. I look forward to you joining us each Monday between 4 and 5 o'clock when we film right here in our studio in downtown Honolulu. The show, Think Tech Asia, focuses on contemporary events in Asia. And by Asia, we mean anything from Hawaii, south to Australia and New Zealand, west to Pakistan, and as far north as the Russian Far East. Clearly, this is one of the most economically dynamic centers of the world, and we bring you up to date on what's going on in a whole host of countries in this very vital region. We look forward to seeing you. Aloha.
Oh, I'm back on the air. My little ear thing is gone out. That's okay. We're all good. See, I put it back in real quick. All right, we're back on the air, as you all can see, and we're here again with my guest, Myles Breiner, attorney Myles Breiner, and we're talking about some of the things that have become extremely public over the last year in Hawaii with respect to prosecutorial misconduct. The Didi case is one. There was also an issue of a couple of weeks ago where a prosecutor in open court, I couldn't believe this, man. I mean, I'm sitting there, I'm doing my morning thing, reading the Star Advertiser, and I see where this prosecutor has made a closing argument and basically talks about judge send a message to the Micronesian men that they can't go out and drink and then getting into fights, and you know how these Micronesians are. And I'm sitting there thinking, man, am I back in the 1920s in Alabama, where somebody would feel comfortable enough to say that. And also, so I went to the Court of Appeals. I read the Court of Appeals decision in that case. I think it's State versus David. And they were talking about how there was also discovery violations. And so I'm sitting there thinking, well, don't you think the discovery violations and his racist intent was all related?
All of it. The sad part is, nothing's happened to that prosecutor.
Nothing.
He wasn't sanctioned by the court. I mean, so the case got reversed, okay? What really should be happening is a referral to the disciplinary board. His license should be suspended.
If you would have made that argument in California, man, or any other place on the mainland, he wouldn't have got through he wouldn't have finished his sentence.
Well, one of the cases that the court referred to in reversing the conviction was the case involving an attorney who's the prosecutor's office at the time made a reference in his closing argument how terrible it would be coming home and finding your daughter in bed with a black man.
Yeah,
and they got a conviction in that case, but fortunately the public defender assigned to the case immediately objected. The case went up on appeal and it got reversed. But nothing happened to that prosecutor.
That's crazy, man.
And the court wrote it off as in the excitement of the moment, people say things like that, which is, it's pretty amazing to come up with something like that. It's like,
well, you got that incident. You got the incident where there are lots of cases being dismissed because the head prosecutor says, well, these cases they ran out of time on the statute of limitations, whatever.
Can you imagine the family? There was a negligent homicide case that sat in the drawer of the deputy prosecutor, the senior deputy prosecutor. He's still there. He used to be court counsel. Before that, he had been a prosecutor, then went to the corporation counsel, and came back to the prosecutor's office under Kaneshiro. He's practiced probably 35, 40 years. He left the file in his drawer and didn't get it to court to indict the case or to go to preliminary hearing and charge it. The result is Mr. Kaneshiro had to take to the news, spoke to the media, and apologized. Well, how does the family feel?
Yeah.
I mean, there's no vindication, there's no resolution. A family member is killed, albeit in negligent homicide, they're dead.
And someone's gotten away with a homicide, albeit negligent.
And nothing's happened. Nothing's happened regarding the prosecutor's office other than a mea culpa, and Mr. Kaneshiro's explanation was, we're only human.
That's
a very low standard if you're prosecuting people and charging them or not charging cases, but more importantly, charging people and making mistakes, and then the response is, we're only human? What about the 9 defendants in the gambling case? As I said earlier, they lost everything they had, all their businesses are gone, none of them are working right now, they're having difficulty, as it is difficult to find full-time employment in Hawaii in the present state of the economy. Imagine losing your own business when you're a sole proprietor.
And here's what bothers me about your case with the gambling and the Diddy case. They both were done maliciously. In this sense,
Well,
and you don't have to, this is my opinion, you know, when you're within 24 hours of that civil suit being taken up to the Court of Appeals and the federal court, they're charged with these 414 count indictment, right? And then to send that indictment out to the news and to it's like I'm going after, you know what I mean? It's not just prosecuting. You know, really,
it was clearly
it's seeking
personal.
vengeance, right? In the Diddy case, not to charge manslaughter because you're trying to, you know.
Well, interrupt you one second. The Diddy case presents certain interesting problems because the case originally was always charged as murder. The first trial, murder in second degree. Both the defense and the prosecution stipulated that there was no factual basis to give a manslaughter instruction.
Right.
Now, there obviously was mistrial. Second trial, prosecution's taking the same position. They argue in their voir dire to the jury, in jury selection, they only talked about murder. Didn't talk about manslaughter or any of the lesser included. In their opening remarks, they only talked about murder. In their closing remarks, murder. In fact, they even told the jury in their closing remarks that there's no basis to conclude that this is a manslaughter case.
Right.
And the defense did likewise, saying this is a murder case, and we presented evidence of self-defense and defense of others. Now, the court still gave the manslaughter instruction. What's interesting is, say, the jury comes back, acquits on the murder, and just can't decide doesn't even address the manslaughter issue. Now the prosecution is getting ready to retry this case all over again on manslaughter. So the hypocrisy,
Yeah.
you know, is astounding.
To charge me with something you've already said I didn't do. That's the problem. See, you charge me with a crime you've already said in open court twice. I didn't commit. If that's not malicious, I don't know what else is.
Clearly it's vindictive on the part of the prosecution because they repeatedly told the grand jury this is actually a murder case.
Told the judge under
They
Rule
told
29.
two juries in a row this is a murder case and there's no basis to give a manslaughter instruction. Yet now they're going to go forward in a few months. They're going to proceed to go to trial on a manslaughter case and they're on record saying there's no evidence of manslaughter.
You're charged me with a crime you say I didn't commit. You've said I didn't commit this crime and you're going to still charge me with it? Man, they ought to be locked up.
Well, the bottom line is that the prosecutors, in my opinion, have the right judge. This is a judicially driven decision. In front of a different judge, I think it would be a different result.
Can you get it? Could Tommy, who's not representing Mr. Diddy, and let me put this on the record. One, I think Diddy should have been convicted. Now, you know, I represent a lot of brothers that got shot by the police, man, so I'm telling you right now, but that's beside the point.
Again, because we're just looking at the law.
I'm just
at
looking
the
at
way
the
it
law.
was charged, and the prosecutors decide who's
I'm with you on the law.
case.
I'm just letting the people know. You know, my heart's still with the guy that got shot, not with Diddy. But on the law, on the law, could Tommy take this to the federal court and enjoin them from prosecuting him?
It's something they're thinking about. Right now, there's 4 motions pending before Judge Karen On regarding the Diddy case, going forward with it. Some of the issues have been argued previously by Brooke Hart, who had the first trial, and also argued by Mr. Otaki before the second trial. There's state constitutional issues. That's double jeopardy under state constitution, double jeopardy under the federal constitution. There's also separate issues about prosecutorial misconduct in presenting a case to a grand jury, arguing before 2 separate juries that it's a murder trial, absolutely no, and saying there's no rational basis for manslaughter instruction. So for the prosecutors now to proceed on a manslaughter where they've previously emphatically stated there's no basis, and the standard being a rational basis on the evidence, having stated there's no rational basis based on the evidence for manslaughter instruction, to now proceed to trial on something that they're on paper saying there isn't a basis for is outrageous.
It's vindictive. And that was the point. That's how I tied into the gambling case. To me, that was just vindictiveness, man. And you don't want a prosecutor in office who's not seeking justice. What he's seeking is vengeance, right? And that's not what prosecutors' jobs. You were a prosecutor. You know that as well as I do. Your job is to seek justice, even if that means telling the other side, you know what, I may have been wrong, right? Because it's not personal.
Now, maybe, I understand. Your position is you think that Dee Dee was guilty of manslaughter. The fact is, it shouldn't even be on the table at this juncture.
I agree.
You know,
I agree. He should have done it right the first time, but he was being vindictive.
And the fact that the prosecutors want to proceed now on a theory that they completely dismissed twice.
I agree with you 100%, Myles.
It's so offensive to fairness, and that the judge would allow it to go forward and not rule on any of the bases, whether it's state versus Milwaukee or the other cases cited, whether state or federal law. It just seems patently unfair.
I mean, even after the last one, I would have just said, you know what, we don't even want to talk about manslaughter. You've already said it didn't exist, so it's over with. I mean, that's what a judge should have done, you would think, because here's a man that's now on trial 3 times for something you can't get a conviction on twice. And you could have done it right the first time, but you, the prosecutor, chose not to indict under manslaughter, which would have given the man a chance. And based on that, he being the defendant is paying the price for your mistake, for your vindictiveness. It's the same with your client. You know, to lose my business, to have my family devastated because you went out on a witch hunt, and then to put somebody in that grand jury room who said they only had 2 weeks to look at the case, and they didn't look at the case, and they indict my client, and you say that, what, this is justice? And you must be out of your mind.
Well, sadly, the public gets what it asked for. It elected Mr. Kaneshiro.
That's it.
You know, and they support him. Submit that Mr. Kaneshiro should seriously consider resigning. I doubt he will. But the fact is that the public really should take a hard look at what's going on with the police department. We have the chief of police who deliberately, in my opinion, destroyed the trial where his wife was going to be compelled to testify. There's terrible conflicts of interest here with the prosecutor's office and the police department. If they're involved in civil litigation, they shouldn't be prosecuting the same cases that they're being civilly sued on. Apparently, Mr. Kaneshiro had no problem with a conflict of interest. And in fact, the irony is that in the underlying gaming case or gambling case, he assigned the chief's wife as the lead prosecutor on the criminal case.
So my point was the chief was a defendant in a civil suit in a federal case. Once the federal case gets appealed, i.e. we're still fighting you, chief,
right.
Within 24 hours, his wife and this other guy in there indicting somebody on 414 counts.
And the other attorney had cost the city and county of Kauai over nearly $300,000 in penalties for prosecutorial misconduct in the Bynum case.
Oh man, that's a hell of a civil
suit. Several weeks earlier, several months earlier, he had to resign from his job. He was essentially on the verge of being fired because of the cost of misconduct in prosecuting a case against the city council member Bynum. And then here, Kaneshiro, notwithstanding this egregious errors over in Kauai as a prosecutor, Kaneshiro hired him and assigned him to the largest single criminal indictment in state history.
Genius at work.
There you go.
You know, but we're going to sum it up here. You know, one, I'm glad that you're here, man. You know, I don't know how, if Hawaii really appreciates the gift that you've given them, which is a guy who's going to stand up and fight for justice, you know. And I've tried cases in a lot of different cities, man, and I'm just telling you, people like you are rare. And I'm proud to know you, brother. You make my life a lot more fun.
And entertaining.
All right. Until next week, this is Ken Lawson signing off on Life and the Law, and we'll see you back next week.